Straight ahead on Law&Crime Daily. Britney Spears' conservatorship battle is back in the courtroom, and this time a judge rules against her father.
What has gone down has been unethical, and the process has not been due for her.
Defense attorneys for the former president present their case at the Trump impeachment trial. We break down their First Amendment claims.
It is constitutional cancel culture.
Did the former attorney general interfere in a plea deal in the George Floyd case? Our experts take on a report of Bill Barr stopping a bargain for ex-cop Derek Chauvin.
He did not want to put his thumb on the scale of justice.
Plus, a grand jury's decision on whether officers should be indicted for pushing an elderly protester to the ground.
The grand jurors voted to no bill the case, which means that they dismissed the case. All right?
Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm Brian Buckmeyer along with Terry Austin. Britney Spears won a small victory in court this week against her father, Jamie, in her conservatorship case. Angenette Levy is here to tell us more about it and the attention the case is getting.
Yeah, Brian, Britney Spears wants her father, Jamie, removed completely as conservator of her estate. A judge ruled this week that Jamie Spears and a trust company will manage Britney's finances together, but the conservatorship battle continues.
Hey, hey, ho, ho, the conservatorship has got to go.
Outside the Stanley Moss Courthouse in Los Angeles, members of the Free Britney movement chanted their support for Britney Spears.
What do we want? Free Britney! When do we want it? Now!
Spears has asked a judge to remove her father, Jamie, as conservator of her estate. The court has already named Bessemer Trust as a co-conservator at Spears' request to manage her finances.
Why can't she choose what she's able to do from her day-to-day? Why does she have to get approval for who she can hang out with? Why is she not allowed to choose who she wants in charge of her assets?
Bible Girl is a Free Britney advocate.
Britney has been a person who's been with me when no one else was.
She and others attended a virtual rally during the latest hearing in Spears' case. Spears' lawyer says she doesn't want her father as conservator, while Jamie Spears' lawyer says Britney said in 2008 that she wanted him in charge.
Anytime there's that amount of money to be made, you have to question the motives of everyone close to that person.
The New York Times documentary, Framing Britney Spears, has brought more attention to the conservatorship battle. Spears' first attorney said in it that Britney never wanted her father named conservator, even back in 2008. And recordings of Spears have emerged where she claims her father threatened to take her children away if she ends the conservatorship.
Free Britney! Free Britney!
Meanwhile, Britney Spears' fans say they have her back.
We're out here keeping the heat on the conservatorship case. We want the judge to know that the world is watching, and we want her to make the right decision and rule in favor of Britney.
I feel like it's a big deal. I mean, this is someone's life. I know that doesn't affect any of us, and it's not very that important to all of us, but this is someone's life that is very important.
And Jamie Spears had objected to any attempt to limit his control over the estate. The judge ruled that Bessemer Trust and Jamie Spears should work together to come up with a budget for the estate. The next hearing is next month. Brian?
Thanks for the update, Angenette. Joining us today is defense attorney and former prosecutor Bernardo Villalona and Terry Austin. Terry, with co-conservatorships with equal power over Spears' estate, do you foresee any fighting in between these two parties that can maybe, I don't know, bring more light to the conservatorship?
You know, I think there might be some fighting between the two. I know that the judge obviously decided long ago that they should have this co-conservator. But remember here that the Bessemer Trust is making some decisions in favor of Britney, and Britney is a little bit concerned about what her father's going to do. And I think he's concerned that he's losing power. So that's why he's made these recent motions. And the judge has basically said, look, you're going to have equal power. You can't make decisions by yourself.
Yeah, that power struggle between the two is going to be very interesting to watch. Bernarda, a minor victory, but a victory nonetheless, with Britney Spears having a co-conservatorship of her choosing. What do you think the next step is for the Free Britney movement?
Well, Brian, this case is going to be a long battle. I mean, this was just a small step in favor of Britney, but it's no way to the end. What I think the Free Britney movement is looking for is that ultimately Britney decides that she wants to do another tour or perform again, because Britney Spears has said that she is afraid of her father, and while her father has control over her estate, that she will not perform again. So hopefully there is still some kind of hope for the Free Britney movement, but I think this is a case that's going to be in the courts for many years.
Yeah. Now, Angenette, as we saw there was a lot of support outside the courthouse for Free Britney. I would not have bet against that. Angenette, what are both sides saying after the hearing, though?
You know what, Brian, it's interesting, too, that you mentioned the support outside the courthouse, because there was also a lot of support at that virtual rally. At least 1,000 people were in there. That was the limit. And I actually tried to get back in and was barred because it had reached the 1,000-person limit. So this is a big movement out there. All of her fans, lawyers for both sides have not gotten back to me. I reached out to Britney Spears herself. She has not responded. Jamie Spears' lawyer has said, though, in the past that the estate has flourished under his watch. It went from being in debt to having $60 million in the bank. So they're saying, look, he's been doing a great job. You know, he should stay on this. So there could still be another petition from Britney's lawyer to remove him as conservator. As Bernarda said, she's not going to tour again until her dad has been removed as conservator.
Yeah, this is just one more chapter in the long book that is this conservatorship battle. Thank you all for your contribution. Still ahead on Law and Crime Daily, the Supreme Court halts what would have been the first execution of a death row inmate this year. But first, does the First Amendment protect the former president from accusations of inciting an insurrection? Our legal analysis after the break. Attorneys for former President Donald Trump are presenting their case in the Senate impeachment trial. They say the president is protected by the First Amendment.
Mr. Trump was an elected official, and there is an entire body of law, Supreme Court landmark cases supporting the conclusion that Mr. Trump actually has enhanced free speech rights because he is an elected official.
Attorneys for Donald Trump cited several landmark Supreme Court cases, including Wood v. Georgia, which overturned the conviction of a local sheriff for interfering with a grand jury's investigation.
The court held that the First Amendment protected an elected public official's speech because the voting controversy directly affected the sheriff's political career.
In another landmark case, Bond v. Floyd, the Supreme Court said the state legislature could not punish an elected official accused of advocating for burning draft cards during the Vietnam War.
The Supreme Court held that the Georgia House of Representatives was, in fact, forbidden by the First Amendment from punishing Bond, by not seating him, for advocating against the policy of the United States.
And a third case, Brandenburg v. Ohio, which ruled in favor of Ku Klux Klan leader Clarence Brandenburg, who invited a TV station to film a rally in which he called for revengeance against African Americans, Jews, and those who supported them.
The film was taken on a remote, private farm in which apparently there is no evidence whatsoever that these people were not invitees present on that farm by authority of the ownership of the farm.
The defense already facing pushback from 144 leading First Amendment lawyers who signed a letter calling the arguments, quote, legally frivolous, including father of Law and Crime founder Dan Abrams, Floyd Abrams.
He was telling them to go, and he would go with them. He never used the words, take down the Capitol, but he used a lot of incendiary language about something which was literally about to occur.
You'll never take back our country with weakness. You have to show strength, and you have to be strong.
The reality is Mr. Trump was not in any way, shape, or form instructing these people to fight or to use physical violence. What he was instructing them to do was to challenge their opponents in primary elections, to push for sweeping election reforms.
Here to break down the defense's arguments during the impeachment trial is defense attorney Bernarda Villalona and Terry Austin. Terry, the defense argued a few SCOTUS cases, one of which was Bond v. Floyd. You researched the case and thought that it wasn't quite on point. Why?
you know, the Bond case was totally different from what's going on now with the Trump case. Julian Bond was a civil rights leader, and he basically said that he was against the Vietnam War. And because of that, Congress said, no, you can't be a part of Congress. Well, the Supreme Court said, well, yes, you can. You can express your point of view and still serve in Congress. So that's a punishment that is not going to be upheld. What Trump is doing is, in his rally, he specifically said, go to the Capitol. He specifically said, fight. And he knew for a fact that they were going to do that. And he didn't do anything once the violence took place. So it's totally different. There was no incitement of an insurrection in the Bond case.
And ironically, Bond was arguing that he was a pacifist and did not want to participate in the war for that purpose. He wasn't encouraging people to go out and, I don't know, storm the Capitol. Bernarda, the defense pointed to political hyperbole of Democrats to show not whataboutism, but that this is just how politicians speak. What did you think of that argument?
Well, what the defense did is that they performed and put out a mixtape of different statements made by Democrats. And in doing that, what they tried to do is what I call smoking mirrors, is to take away the focus of what these jurors are here to do, which is decide whether the speech was one of incitement. We know what Trump said. If you don't fight like hell, you're going to lose your country. So based on that, where he's intentionally sending them to fight, he knew the power of his words, and then taken into context of how it took place and when it took place, obviously he definitely incited them and wanted violence to take place.
All right. What's still going on? We'll keep an eye on the impeachment trial. Thank you both. Coming up on Law and Crime Daily, an Ivy League murder. An MIT graduate named as a person of interest in the death of a Yale student. Plus, an update in the prosecution of the officer accused of murdering George Floyd. Has he accepted a plea deal? The rejected offer, next. New reaction to a reported plea deal offered in the George Floyd case and how the nation's former top prosecutor intervened in the bargain. According to a report by the New York Times, Chauvin had agreed to plead guilty to third-degree murder and a 10-year prison sentence. But the report says then Attorney General William Barr rejected the deal because he was worried it would look too lenient. The Times said the deal needed federal approval because Chauvin asked to serve his time in federal prison. A judge presiding over the case also denied the state's request to reinstate third-degree murder charges against all 4 of the former Minneapolis police officers. Chauvin is now facing 2 charges of second-degree manslaughter and second-degree murder. Former federal prosecutor Gene Rossi says Attorney General Bill Barr made the right decision.
Chauvin's attorneys went to the Justice Department and said, listen, if the Justice Department closes or does not open a civil rights investigation, criminal, which is a tough road to hoe, if you don't open that, I will go into Minneapolis State Court, I will eat a third-degree murder charge and serve at least 10 years, okay? That's what happened here. The Department of Justice does not prosecute state murder charges unless it's on federal property. So that's what happened. You stop feds from investigating me for civil rights, and I'll go into state court and I'll eat third-degree murder. And Bill Barr did the right thing because he didn't have all the evidence, he didn't have all the facts.
Quick side note, the state's motion to the Court of Appeals to rejoin the 4 ex-cops case was denied, and Chauvin will proceed to court alone on March 8th. Now, here to discuss the report of a plea deal negotiations in the George Floyd case is Bernarda Villalona and Terry Austin. Bernarda, you're a former prosecutor. Was this the right move by former Attorney General William Barr?
It was definitely the right move for a former Attorney General Barr to just stick his nose somewhere else, because for him to have taken part in an investigation and a prosecution that belonged to the state and not giving them opportunity to do the investigation would have been too much for the people of Minnesota, as well as the people from this country, to be able to respect. So for Barr to have said no to the plea deal, I think is definitely acceptable. This is, again, it's a state case. What's interesting enough is that the court has already dismissed the third-degree charge. So that was the case, the charge that they were looking for Chauvin to actually plead to. So that is no longer an option for Chauvin.
I mean, I would agree with you and Gene Rossi, but Terry, playing devil's advocate, wouldn't it be quick and easy just to take this plea deal, much like they see in sexual assault cases, to resolve it without having to re-traumatize witnesses at trial? Could that have been a reason to take the plea?
Yeah, honestly, Brian, there are always two sides to every issue. I mean, on the one hand, a swift and fair resolution, and I emphasize fair, could have spared the public this tragedy to go through this again. But you have to make sure that the punishment meets the gravity of the crime. And I think here there might be many people who believe that 10 years is not nearly enough.
Yeah, I can definitely see that after that video we saw of George Floyd dying. A lot of people would have been very angry at 10 years, especially when you compare it to other charges. Thank you both. When we come back, video shows 2 Buffalo police officers pushing an elderly protester to the ground. Why they won't be facing charges still ahead. Now to New Haven, Connecticut, where authorities say an MIT graduate is a person of interest in the murder of a Yale grad student. Authorities are on the hunt for Kingsian Pan in connection with the murder of Kevin Jiang. Police say Pan was in possession of a stolen vehicle in the area at the time Jiang was shot and killed. The North Haven Police Department say they came into contact with Pan soon after the killing. Witnesses to the murder report seeing a shiny new black vehicle flee the scene. New Haven Police Chief Otaniel Reyes says they're on the lookout into the possibility of a romantic connection linking the suspect to the victim.
The New Haven Police Department's homicide unit is looking for Mr. Kingsian Pan, date of birth of 4/16/1991. We know that Mr. Pan is a graduate of MIT and has an affiliation with that university. I am asking that the public knows that Mr. Pan should be considered armed and dangerous, and that extreme caution should be used if you come in contact with this individual. We are exploring every angle related to this investigation and related to every person involved, the victim, his fiancée, his extended family, and to include the suspect or the person of interest that we've identified here before you. And so at this point, we're not prepared to tell you what our information is regarding their involvement, or whether or not there is a connection between that and this investigation. What we can tell you is that we are exploring that.
The U.S. Supreme Court blocked the execution of Alabama death row inmate Willie B. Smith III, scheduled for Thursday night. The justices upheld a lower court stay on the grounds that his personal pastor must be allowed in the chamber with him when he receives the lethal injection. Smith was convicted in the 1991 abduction, robbery, and murder of 22-year-old Shamal Ruth Johnson. A spokesperson for the Alabama Department of Corrections said the execution would not proceed because non-prison staff are not allowed in the room for security reasons. Criminal charges against 2 Buffalo police officers have been dismissed. Officers Aaron Tolgowski and Robert McCabe were charged with felony assault after videos show the officers pushing an elderly protester to the ground last summer. 75-year-old Martin Gugino was among 20 demonstrators protesting the death of George Floyd after curfew. The fall left Gugino with a brain injury and a fractured skull. Grand jury voted no true bill, leading to the dismissal of the charges. In a press conference announcing the grand jury's decision, District Attorney John Flynn adamantly stood by his decision to charge the officers.
I do not manipulate charges at the time, and still to this day, I'll stand by the fact that charges should have been filed, and there was probable cause at that time to charge that offense, and I stand by that. I make no apologies for it, and if I had to go back over again, I'd do the same thing, without any question about it. Looking at each one of you in the eye right now, and I am telling you that I sandbag nothing. I went into that grand jury, I put all relevant evidence into that grand jury. I put multiple witnesses in that grand jury, okay? I put everything that was not cumulative into that grand jury. And you got my word on that. And again, that's all I can say.
Here for legal analysis on the lack of an indictment in Buffalo is Bernardo Villolona and Terry Austin. Bernarda, this doesn't make sense to me. From someone, I mean, both of us practice here in this state, you got to prove two things. You got to prove he's over the age of 65 and that he was injured. I'm not asking for these officers to get locked up, but no indictment? This makes no sense. What do you think?
Exactly, especially when you're talking about a grand jury presentation, because a grand jury presentation is a different burden of proof. You don't have to prove the defendant's guilt beyond a reasonable doubt. So I don't know why is it that a grand jury, at least 12 of those grand jurors, decided to issue or render a no true bill, because we already know, look, the victim is over 65 years old. Both police officers are at least 10 years younger. And the intent of those officers when they placed their hands on the body of this victim and pushed him down speaks for itself as to the intent to cause physical injury. So unfortunately, because there's a no true bill, the minutes are sealed, so we will never know what was presented to that grand jury.
It's just peculiar. It doesn't make sense based on, I think, what we both know and understand in the state of New York. Terry, what was your reaction to no true indictment, and do you think there's a possible civil claim here for the victim?
Well, you know, I agree with you both. I think this shocks the conscience. There's no question that a 75-year-old man wasn't a threat to anyone, and you could see that in the video. You know, as for a civil case, anything is possible, and I haven't seen anything yet, but they could file a claim for negligence here because the police officers owed a duty to this individual, and they failed that duty, and he was definitely harmed.
Yeah, not just a harm, but not helping afterwards. I mean, Bernarda, Terry, thank you very much. And thank you for joining us here at Law and Crime Daily. We'll see you next time as we discuss justice in America.